that only Republic TV is bringing to you and giving you a closer look and raising the questions. It's a big controversy over the Supreme Court order in the Sandesara case, which allows all criminal proceedings against the family, Sandesara family, to be quashed if they deposit 5,100 crore rupees before the court. The court in its 21-page order says that this amount will be full and final and kept in an interest-bearing account and later dispersed to lender banks. But the key debate here is around the point that despite the sweeping relief, it is the court's own caveat that this order is in the peculiar facts of this case and should not be treated as a precedent. Now, if the payment is made, the Sandesara stand to walk free from CBI, ED, PMLA, SFIO, and FEOA, Income Tax and Black Money Act cases as well, essentially putting a complete end to the years of litigation. Is this now, viewers, a one-off settlement or the precedent in disguise that could let economic offenders buy freedom? Shravan Sen joins us live on the broadcast from the newsroom. Shravan, well, this is a big story that only Republic TV is shedding light on. And if you could just share the charges that have been against the Sandesaras and what is this settlement and what precedent is it really setting?
Well, in fact, the case was registered in the year 2017 by the Central Bureau of Investigation, and the accused in this particular case were Sterling Biotech Private Limited, along with that Nitin and Chetan Sandesara. In fact, this very case was thereafter taken by the Enforcement Directorate. The initial complaint was with regards to a loan that was received by Sterling Biotech Private Limited worth about 5,000 crore rupees. Now, as the investigation essentially progressed and it turns out that they had taken several loans which had basically turned NPA, non-performing asset, it was roughly about 10,000 crore rupees that was declared as fraud by the bank at that point in time, following which the Enforcement Directorate had already attached assets that were about 506 movable assets that were spread across various countries, including Nigeria, where that was the last location to which they were basically traced to, Nitin as well as Chetan Sandesara, pictures of it which have also been accessed by Republic TV. Now, it's important to point out that while all of this actually was happening, there is a COC, which is a committee of creditors consisting of banks that was headed by Andhra Bank. They had basically started this entire process of the insolvency resolution process, which essentially means that this was an offer that was given about one-time settlement, which is also known as the OTS. That offer was essentially given. It turns out that this is exactly what was accepted by the court. In the Supreme Court allowed Sterling Biotech Private Limited and the Sandesara brothers to give a fraction of the amount back to the banks and settle this entire matter. What has essentially happened is that the civil liability against the Sandesara brothers have now been cleared, which effectively means that the criminal case that has been registered against the Sandesara brothers also goes away because of the one-time settlement that has been given, which essentially means that it is almost like a golden ticket that has been given to economic fugitives. Because remember, in all these bank fraud scams, starting from Vijay Mallya's case to Nirav Modi's case, and of course Mehul Choksi's case, in all of which the Enforcement Directorate has attached properties worth crores. And it turns out that after the properties have been attached, the Enforcement Directorate begins what is also known as the restitution process. That is, sending it back to the banks. That is basically monetizing of the attachment that has taken place. As far as Vijay Mallya's case is concerned, it is over and above the fraud case itself. Now, it is important to point out here that there is also a principal interest that is attached to the amount that they have defrauded the banks. And that is exactly what the Enforcement Directorate has basically tried to recover. In this particular case also, remember, because of this almost a clean chit that has been given to Sterling Biotech, you have the Enforcement Directorate as well as Central Bureau of Investigation unable to take forward this entire case. In fact, these are the case papers that we have basically got. And what I understand from the case papers, the Enforcement Directorate as well as the Central Bureau of Investigation back in 2022, they were basically prevented to carry forward any of the investigation because the Honorable Supreme Court at that point in time had said that all proceedings must remain in abeyance till we consider the matter whereby the promoters had basically offered the deposit of 900 crore rupees with the court and the Supreme Court. It seems that even after that, the Enforcement Directorate was not party to these entire proceedings. They had basically filed an interlocutory application. Now that matter was also kept in abeyance. Now it has got a direct impact, if not to the restoration process, but of course in the days to come, in the months to come, when the matter is going to come up in the court, particularly in the case of Vijay Mallya, Nirav Modi, Mehul Choksi, all of them essentially would have the option of actually indicating the fact that they are willing to go ahead with the OTS, which is a one-time settlement, allowing them to perhaps carry on with their entire proceedings or with their entire business by only making a fraction of the amount to be paid back to the banks. Our legal editor is also joining us on this broadcast. Rhythm, the case papers that we have essentially gone through indicates that the agencies were basically stopped from carrying out their entire investigation by the court. 2 years back, this entire case of Sandesara was put in abeyance because the Supreme Court had to take a final decision based on the offer that was given by the promoters of, depositing about 900 crore rupees.
So what I'm seeing in this order, Shravan is and Rakshita, that the court has noted on November 18 the amount in this FIR was 5,383 crore. It's recorded this one-time settlement amount is going to be given to these people. These companies was earlier of 3,826 crore. For the foreign guarantor companies was 2,935 crore. These people deposited 3,500 crore under various heads, leaving dues of 3,253 crores. Banks had recovered a certain amount, is what the court noted in this. The Solicitor General of India, Tushar Mehta, placed before the court in sealed cover the proposal seeking 5,100 crore to close all issues. This is when they agreed to deposit this amount to end all proceedings in this writ petition. The court accepted the consensus, held that continuation of the criminal cases would not serve any purpose in the facts of the case. The Supreme Court held that all the aforementioned proceedings against the accused will stand quashed once the petitioners deposit this money by 17th of December with the registry of the Supreme Court, and it's directed them to verify all these details. We've seen that we have Solicitor General of India, all right, is also appearing for them. But I also want to go across now to senior advocate, one of the country's top lawyers, Mr. Sidharth Luthra, who's joining us live on the story. Sir, we've seen the peculiar facts of this case. If you could please make us understand, is this not going to be a bad precedent in the case of fugitive extradition, fugitives like Mehul Choksi and Vijay Mallya, who already escaped to the lap of luxury, are going to enjoy the benefits of this judgment of the top court?
So let's go back to the Bhopal gas tragedy. Initially, on payment of compensation, all criminal cases were quashed. But later on, the Supreme Court recalled its order. Come a few decades later, the Supreme Court had looked at these matters and said, we should allow cases to be quashed. That's about 2 decades later. And then about a decade ago, the Supreme Court again changed its view and said, cases of corruption should not be quashed. Having said that, the issue is, as this case, as in many other cases, the courts will try and balance equities, that is recovery of money, crimes of corruption, as also the collection of the dues of the banks. Now, in this case, as in other cases where similar settlements have been accepted, courts have acted in terms of the Supreme Court alone. The High Courts can't do it. The Supreme Court alone has acted in exercise of its inherent powers or its constitutional powers in what they call doing justice under Article 142. Now, that is a power which is not trammeled by any law, not controlled by any law necessarily. Of course, if there is a law, Article 142 may not be given recourse to. So this is something in an extraordinary case, in an extraordinary power has been done. Will it help other fugitives or other people? It might. Absolutely. You're absolutely right on that. Because people who have not submitted to the jurisdiction of Indian law may try and say, all right, we'll pay the money, please close the criminal case against us, which is not doable by ordinary courts. Even the High Court but only by the Supreme Court. So that is the legal position.
Mr. Luthra, you are one of the country's top lawyers. You specialize in criminal law. And over the last few decades that I've spoken with you, sir, we've understood from you that fugitives and others will try and derive benefit from this judgment. Like you said, it's possible they might. This is
You're
something they will
absolutely
try
right.
and use, whether it's Vijay Mallya. So how is it that the Supreme Court says it's not going to be a precedent? It's the law of the land now.
So no, I must tell you, there are many cases where the Supreme Court has exercised its powers under Article 152 and declared it not to be a precedent. That is to say, it is the power of the court to do what they call to find a balance, to do justice, or to find a solution, which will not apply to other cases. This has been the principle which has been applied. I remember way back in the 80s, there were cases where there were attempt to murder cases which were settled by the Supreme Court, Exercise 142, and the same line came, it will not be treated as a precedent. Even sometimes in bail cases, where courts do grant bail to certain offenders accused perhaps of what we call grave crimes, they have indicated that that order will not be precedent. That is to say, no other litigant can take advantage of that. So this is a mechanism that the court uses to settle certain matters while not settling the position of law. However, in practice, and as you rightly noted, in practice what happens is that time and again litigants will make a chance using this judgment to say, if you could do it in one case, our facts resemble the facts of the Sandesara case, Sterling Biotech, why can't you do it in our case? So that is something which does happen as a matter of practice, and it adds to the docket of the court.
Yes. And, sir, we've been discussing this case in a first of its kind order to drop criminal proceedings in a multi-crore bank fraud after the accused agreed to pay back the money. We've seen so many cases like this. I know I'm reiterating the same point, but how is it when the ED...
It's been done. Rhythm. It's been done in a number of matters. As I said, the law initially allowed for it. Then a different view was taken by the Supreme Court. Now, whenever they do it, they orderly will use the words not to be treated as a precedent. That is limited to that particular case and no others. So, on a case-by-case basis, Article 142 powers are exercised in such matters. It is exercised in a variety. This is a case of financial fraud. There are cases not of financial fraud, but there are cases, let's say, of matrimonial matters where there are myriad criminal cases and taxation issues and other disputes. Courts have used powers under 142 even in such cases, or where there are family disputes, or where there were large commercial disputes. So this exercise of 142 power has gained some level of acceptance, not only acceptance, I will say popularity with the court to try and find solutions where the law does not permit such a solution ordinarily.
Mr. Luthra, yes, but is this pragmatic move of the Supreme Court prioritizing the recovery of public funds over prolonged litigation going to be seen as such? Because the court said these are peculiar facts. Is this not going to be seen as a sweetheart deal for another fraud crony?
So, it's a matter of perspective. The fact is that there is a financial loss to the banks. The fact is that there are allegations of fraud. But the fact is, the only way this matter could be resolved on a one-stop, the OTS could be accepted, would be if the court had intervened. And frankly, don't forget, don't put everything in the lap of the court. You're doing this. That's something which I find is almost a swan song of your comments through this conversation. Remember, it is the government which came out with a sealed cover OTS proposal. So if the government is willing to do it, the court has only put an imprimatur on what the government was willing to do as an OTS.
Yes, yes. It's a one-time settlement by the government that also needs to be put forward. You're absolutely right. It's in a sealed cover that the Solicitor General had given it also. This is also something that needs to be questioned since the ED's case was going on and the facts of the case are clear. Also for the government then, I would just say when there is so much that needs to be seen, Mr. Luthra, is a one-time settlement something that should be done? Almost like giving a clean chit to a 5,000 crore loan defaulter fugitive.
So there you need to ask the two regulators, the Ministry of Finance and the RBI, if they believed that the OTS was possible, it would have been in terms of their rules and regulations. Otherwise, they would not agree to an OTS. The fact is the RBI has guidelines into when OTS cannot be done. And normally, OTSs do not cover criminal cases. Normally, that is to my recollection, the guidelines of the RBI. But in this case, obviously, a special decision has been taken at the level of the government, the Ministry of Finance, as also the RBI, and that has led to the court accepting that OTS proposal, getting the party to pay and close the matter. We should not shift the focus on the court, but also understand that it is two parties who have come together asking the court that because of this settlement, please do away with other matters. And it is the parties that have settled, not the court. The court has just accepted that settlement and given consequential directions.
Yes. Mr. Luthra, I agree with you and thank you for clarifying that and thank you for giving us your precious time. This is something we'll actually be debating and we'd like to have you back on it. We continue to stay with the story. Thank you for your time, Mr. Luthra.
Always a pleasure.
Always a pleasure.
Right, thank you so much, Rhythm and Mr. Luthra and Shavan. This is the big story that we are tracking and also debating tonight at 9 p.m. With Arnab Goswami debating this golden ticket for economic fugitives, the Sandesara settlement by the Supreme Court. Viewers, in the meantime, we shift our focus to the other breaking news that we have right now. All right, the Principal Secretary to the Prime Minister